Before we start with the tutorial, we would love to hear your views about today's topic or our tutorials in general. We appreciate the impact we have on your studies, and we wish to learn how we can improve our tutorials for you. The Introduction to Law 202 introduces legal instrument of payments under the topic of debt review. Did you know? Credit plays a fundamental role in the daily lives of the community. One make use of credit at some point in one's life, as not many people can afford to buy items with cash. The industries available for the provision of credit include microlenders, banks, financial institutions, retailers, and vehicle financiers. Credit lending and over-indebtedness in South Africa were characterized by discrimination, a lack of transparency, limited competition, high cost of credit, and limited consumer protection. Let's look at the regulation of debt review. The National Credit Act No. 34 of 2005 constitutes a scheme for the regulation of various aspects of the granting and receiving of credit. Among several models of regulation in the statute, there is the model of debt review. Debt review objectives are formal intervention into the contractual relationships of debtors, called consumers in the NCA, whose capacity to comply with their contractual obligations to their creditors is compromised, and a constructive rearrangement schedule to ultimately achieve payment to their creditors. Whilst the debt review process prevails, the consumers cannot incur credit, and their creditors cannot sue them. There are distinct portals to 3 channels of access to debt review and a rearrangement of consumers' obligations. The primary channel is that through the portal of Section 86 subsection 1, in which the consumer takes the initiative to approach a debt counselor. By contrast, the second and third channel facilitate the prospects of debt review when a court is seized with consideration of a credit agreement. These latter 2 channels are regulated respectively by Section 83 subsection 1 and Section 85 subsection 1. The addressing of reckless lending is the burden of Section 83. Over-indebtedness is the burden of Section 85. Naturally, the circumstances of a reckless credit agreement and over-indebtedness can be wholly distinct, but also often are intertwined. The distinctions between the criteria necessary to access debt review in these 3 channels are important. Let's look at the first category, application by consumer for debt review. Under Section 86 subsection 1, a debt counselor, upon receipt of the application for debt review from a consumer, incurs a duty to tell the creditors and the credit bureaus of the application having been made. The benefits of immunity from being sued kicks in at once. At this stage, the debt counselor has yet to adopt a view about whether the consumer is indeed over-indebted. The debt counselor must then assess the application. If, as a result of an assessment conducted, a debt counselor reasonably concludes that the consumer is over-indebted, the debt counselor may issue a proposal recommending that the magistrate's court make either or both. A debt counselor who has accepted an application must determine, in a prescribed manner and within a prescribed time, whether the consumer appears to be over-indebted. And if the consumer seeks a declaration of reckless credit, whether any of the consumer's credit agreements appear to be reckless. The debt counselor is empowered merely to make a proposal based on the assessment to the magistrate's court to make an order. Looking at the second category, application by creditors for debt review. Under Section 85 subsection 1, the court is required to consider a credit agreement, and here's an allegation that the consumer party to the agreement is over-indebted, may do one of 2 things. First, a court may avoid taking a view about the allegation of over-indebtedness by referring consumers' circumstances to a debt counselor. Please see Section 85 subsection 1A of the Act. The effect is to propel a consumer into the same position that a consumer would have been in if the consumer had made a Section 86 subsection 1 application, and the debt counselor, having received such application, performs the task of determining, in terms of Section 86 subsection 6A, whether or not there is over-indebtedness. Alternatively, a court may skip the involvement of a debt counselor and go directly to the powers conferred on the magistrate's court in Section 87 to order a rearrangement. Please see Section 85 subsection 1 subsection B of the Act. Thus, a court in such a case does not regard the procedure in Section 86 at all, and thus makes no determination or assessment. which is merely a tentative viewpoint by a debt counselor, but rather makes an order within the confines of the operative provisions of Section 87. Under Section 83, subsection 1 channel, contemplates access to the process in a court or in the tribunal created by the NCA. By contrast, the tribunal plays no role in a Section 85 process. The court or tribunal must declare a credit agreement reckless in order to trigger the powers embodied in the section. By contrast, the court, in terms of Section 85, may declare the consumer over-indebted. Section 83 confers powers to deal specifically with both a reckless credit agreement and the consumer's consequential over-indebtedness. If the court or tribunal does make a declaration of recklessness, the court or tribunal is thereupon also empowered, in terms of Section 83, subsection 3b Roman numeral 1, among other powers, to make an order as contemplated in Section 87. In terms of Section 87, the magistrate's court may rearrange consumers' obligations. If a debt counselor makes a proposal to the magistrate's court in terms of Section 86, subsection 8b, or a consumer applies to the magistrate's court in terms of Section 86, subsection 9, the magistrate's court must conduct a hearing and, having regard to the proposal and information before it and the consumer's financial means, prospects, and obligations, make various orders listed in Section 87, subsection 1a and b. The effect of such an order is the subject matter of Section 88. Section 88, subsection 1 has the function of freezing the consumer's rights to contract on credit and to prevent creditors from suing the consumer. Upon notice of receipt of an application or a notice of the court proceedings in Section 83 or 85, the freeze is effective. The freeze endures until the conditions stipulated in Section 88, subsection 1 or 2 occur. These are the primary exit requirements. Steps to be taken by consumers to exit the debt review process. A consumer whose debts have been rearranged and has settled all the obligations under every credit agreement subject to that debt rearrangement or agreement or demonstrated financial ability to satisfy the future obligations in terms of the rearrangement order or agreement, and that all obligations under every credit agreement included in the rearrangement order or agreement have been settled in full, the consumer must be issued with a clearance certificate by a debt counselor within 7 days. The consumer may apply to the tribunal if a debt counselor decides not to issue or fails to issue a clearance certificate. If the tribunal is satisfied that the consumer is entitled to certificate in terms of Section 71, subsection 1, the tribunal may order the debt counselor to issue a clearance certificate to the consumer. A debt counselor must file the clearance certificate within 7 days after the issuance of such certificate with the National Register in terms of Section 69 and all registered credit bureaus. If the debt counselor fails to file a certified copy of a clearance certificate, the consumer may file a certified copy of such certificate with the National Credit Regulator. Upon receiving a copy of a clearance certificate, a credit bureau or National Credit Register must expunge from its records any information or record relating to consumers' over-indebtedness or the relevant debt rearrangement order or agreement. Upon receiving a copy of a court order rescinding any judgment, a credit bureau must expunge from its records all information relating to that judgment. Can someone exit a debt review by court application? No. It is only the tribunal that is empowered to assist them at first instance. The process is an administrative one. The legislative scheme of the Act is that the lifting of the consumer's disabilities attendant on debt review occurs by way of an administrative, not a judicial, process. The unambiguous effect of the statute is that an over-indebted or financially challenged consumer under debt review who enters into a debt rearrangement agreement can only terminate the debt review by settling his or her obligations to the extent required in terms of Section 71 and demonstrating that he or she has satisfied the other requirements of Section 71, subsection B. The end.